Hi, this is Stuart Albertson, and I want to talk to you about how we keep certain embarrassing evidence out at the time of trial. In every single case, there's always something embarrassing in somebody's background that you can be assured that the opposing lawyer is going to bring out in deposition. And they're going to spend a lot of time talking about this very embarrassing thing that you or one of your loved ones went through in a way to harass you and cause you pain as we go forward in the lawsuit. And as a younger lawyer, I used to object in deposition and try to keep the lawyers from asking these questions, but there's an even better tool, and that is let the lawyers ask these questions, and then what we do is we bring what we call a motion in limine at the time of trial. And a motion in limine is a motion to the judge right before the trial where we say, hey judge, there's some irrelevant, embarrassing information that the other side wants to put on simply to embarrass the person that we're representing. That's the only purpose for it. It's not to help figure out who did what in validating a trust or a will or creating a trust or a will. Its sole purpose is to embarrass the client. So we file those motions with judges, and more times than not, judges are reasonable when they look at these. And they say to the opposing side, you cannot mention this at the time of trial. You can't even bring it up. The other place that motion in limines work really well is the opposing expert. Opposing experts will show up to trial and they will say all kinds of things that are irrelevant or that they are not qualified to testify about. Well, we know that they're going to testify about these things, these experts, because we've taken their depositions. And so we file motions in limine with the trial court, pointing out the chapter and verse in their depositions where they're talking about irrelevant issues that don't need to be brought up, or talking about opinions that have no basis in fact, or opinions they're not qualified to testify about. And we put those to the judge in a motion in limine and ask the judge to keep the experts from clouding the story or clouding their testimony or clouding the issues in the case that are to be determined by the judge or the jury, and we ask the court to keep those things out. So motions in limine are important. They can keep embarrassing facts out that have nothing to do with the case about your past, and they can also keep experts from testifying about things that really shouldn't be brought up at the time of trial.